Good morning. Thank you so much for joining me this morning on our Wednesday webinar. Today, we are going to talk about Social Security disability for traumatic brain injuries. Before we really get started, I do want to take a moment, and to those of us that are joining live on the webinar, we will go ahead and drop a link in the chat where you can schedule a call. I don't answer any questions on the live. If you are watching on the replay, I can't really answer any questions that are in the comments on the replay either. There is a link in the description of the video down below. If you do have specific questions that you would like to have answered, you can schedule a phone call with us there. So that's what I do ask for, is if you have any questions, to please schedule a time to chat with us. I am always happy to answer any questions. That's not why I don't take questions. It's because to give a solid answer that is going to, potentially mean something in your situation, I do need quite a bit of information. So it's just easier for us to do that over the phone. That way you're not providing any personal information to strangers, either on the webinar or on the internet. So with that being said, today we are going to talk about Social Security disability for TBIs. We are going to first talk about some Social Security disability basics. We will then move into Social Security guidance, a couple of potential listings as they relate to TBIs specifically, some considerations related to Social Security claims generally, and then finally we close out all of our webinars the same way, which is how an attorney may be able to help you with your Social Security disability claim. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability, PLLC, which is a law firm based in Florida, where we help clients throughout the country with their agency level SSDI and SSI matters, all the way from initial application through the appeals council level. If for some reason we cannot help you, we do try to put you in touch with somebody who can, or at least somebody who might be able to shed guidance on your specific situation. And so again, that's why when we chat and answer questions, we do ask a lot of information from you. And that is so we can best answer your question. And if we can't answer the question for some reason, that way we've got good information on who might be able to best help you. All right, getting into Social Security disability basics, there are two different Social Security disability programs. The first program is Social Security Disability Insurance, or SSDI. The second program is Supplemental Security Income, or SSI. Both programs require that you be disabled and unable to work for a period of at least 12 consecutive months. You must be disabled and unable to work due to physical and/or mental impairments. So you must have physical and/or mental impairments that are preventing you from working, and it has to last or be expected to last for at least 12 months. So you don't have to wait until 12 months pass to apply. But if you apply before that 12-month mark, what Social Security is looking at is, number one, are you disabled right now? And number two, is that expected to last at least 12 months? So that's what they're looking at, is there's no such thing really as temporary disability by the Social Security Administration. All disabilities payable under SSDI or SSI must last or be expected to last at least 12 months. And I believe with our specific listings too, there are some timelines that Social Security will want to see. Sometimes they'll need to see records for 3 months. Certain listings, not TBI related, are 6 months, 9 months, a year. So it is possible that sometimes Social Security gets your case and they hold off on adjudicating until a longer period of time has lapsed. But you don't need to wait 12 months to apply. I, in fact, encourage people to apply sooner rather than later. It gets the ball rolling. With SSI, it also starts the time period within which you might be able to be paid if you are ultimately found disabled. The difference between the two programs is SSDI is based on what you were able to pay into the Social Security system while you were able to work. So for SSDI, that requires a specific number of work credits. We usually say that you have to have worked 5 of the last 10 years. With SSI, there is no work credit requirement, but instead it's means tested. So there are income and asset restrictions. Generally speaking, you can own one home and one car, as long as you're living in the home. You can have one home and one car. Anything above that is going to count towards your assets. And asset restrictions: you cannot have more than $2,000 in assets if you are single, and you cannot have more than $3,000 in assets if you are married and still qualify for SSI. SSI is also commonly the program that we see children's applications in. And so with that, there are still income and asset restrictions. They do have to be disabled by the Social Security Administration, but the income and asset restrictions they're still the same, but the income kind of differs a little bit based on how many people are in the house, including children. And so those types of questions are usually best geared towards Social Security because they've got their calculators for that. The other overview I want to talk about is the 5-step evaluation process for SSDI and SSI claims. When you first file an application for benefits, this is what happens. Well, the very first thing that happens is Social Security looks at which of the 2 programs you applied for, SSDI or SSI. They're going to first make sure you meet the non-medical requirements. So for SSDI, the very first thing they do when they get that application is make sure you have sufficient quarters of coverage. They make sure that you do have enough work history. Like I said, it's basically 5 of the last 10 years. That does vary, especially for younger individuals. And then with SSI, they're going to first make sure that you meet the non-medical requirements of being below the income and asset thresholds. So that's step 0. As long as you get through those and you've applied for the correct program, then Social Security will look to see, are you engaging in substantial gainful activity? What they are looking for is, are you working at all? And if you are, you don't necessarily have to be getting paid if you're volunteering on a significant basis. If you own a business that you're working in, but for some reason are not turning a profit, they are going to look at substantial gainful activity. So they usually define that as working more than 20 hours a week or earning more than, this year, 2023, more than $1,470 a month in gross earnings. So before taxes get taken out, health insurance, anything else. If you are working more than 20 hours a week or you are earning gross receipts of $1,470 a month or more, you will be considered engaging in substantial gainful activity. The analysis stops there. Social Security will send you a letter denying your case. They would say you are engaging in substantial gainful activity, and therefore, by our definition, you cannot be found disabled. If you are not engaging in substantial gainful activity, your case will move to step 2, where the agency will look at your medical records. And what they're looking for are severe medically determinable impairments. So that means that they need medical records that can tell them what you have going on that's preventing you from working. You have to have at least one severe medically determinable impairment in order to qualify for SSDI or SSI benefits. As long as you have one severe medically determinable impairment, then the case moves to step 3, where you meet or equal a listing. As I mentioned before, we will look at 2 specific listings related to TBIs today. Meeting or equaling a listing can be tough, as you'll see. If you do meet or equal a listing, the analysis stops here and Social Security will approve your case. If you don't meet or equal a listing, then it moves to step 4. And in between steps 3 and 4, what happens is the agency creates a residual functional capacity for you. And they create that RFC based on your medical records. And that RFC is what the agency believes you are capable of doing on a consistent, sustained basis. And that is, they'll typically categorize it as light work, sedentary work, medium work, heavy work. They will also make accommodations for certain mental limitations as far as ability to understand, ability to remember, your ability to, work with others, things like that. And they will take that RFC and they will look at your past work and they will say, can an individual with this RFC perform your past work, either as you performed it, as generally performed, as per the DOT. They will look and see that. If you can go back to your past work, then Social Security denies the case, saying you can go back to your past work based on your RFC. If you cannot go back to your past work, the agency goes to step 5, again, still using that same RFC, to see, can you engage in any other work? Is there any other job that exists in the national economy that an individual with your age, education, and RFC can perform? If so, if you can engage in other work based on your RFC, then you're found not disabled at step 5. If you cannot engage in any other work based on your age, education, and RFC, then you would get a favorable decision at step 5. Okay, turning to specific considerations as it relates to TBIs and Social Security disability. The severity of a TBI can range. Some can be mild and some are more severe. A mild TBI that still allows for an individual to perform most of their activities of daily living with minimal issue is not likely to be found disabling. I always tell people having a diagnosis is not often enough to qualify for disability. The diagnosis does not dictate the disability. What does is the impact that the diagnosis has on your activities of daily living. So I've had clients that get hung up on the fact that, well, my doctor said I have this. My doctor said that, in 10 years, this might happen. Understand. And I understand that that's stressful and concerning. However, what Social Security is looking at is, can you right now, and during the period in question, which is basically when you say you became disabled or when you stopped working to now, can you perform your activities of daily living? That's what they're looking at. Right, wrong, or otherwise, that's what the agency is looking for when they're making their finding of disability. They're not looking down the road at the medical records that your doctor is saying this could possibly happen in 5 years or 10 years. They are more looking at right now what is going on. As I've mentioned, there are 2 different listings that TBI cases can fall into. There's 11.18 if there are physical limitations as a result of the TBI. And then there's 12.02, which will usually cover a TBI without any type of physical limitations. So this is 11.18. This is specifically a TBI listing. And this is going to require, as you can see, either physical or mental limitations. So as you can see in 11.18a, if you have a TBI as well as disorganization of motor function in 2 extremities, arms, legs, hands, shoulders, things like that, resulting in an extreme limitation in your ability to either stand from a seated position, balance while standing or walking, or use your upper extremities. And that extreme limitation has to last for at least 3 consecutive months after the injury. So there's, like I mentioned, some of them, the listings do have a duration requirement. That's this. So you still have to be expected to be disabled for 12 months, but to meet the listing, that extreme limitation has to last for at least 3 months. So that's kind of there's a little bit of a difference there, but you still have to be, even if you meet this, you still have to be expected to be disabled for at least a year. Gets a little confusing. Or if you don't have that, then still 3 consecutive months, marked limitation in your ability to physically function, as well as marked limitation in one of the following areas: either your ability to understand, remember, or apply information, your ability to interact with others, your ability to concentrate, persist, or maintain pace, or in your ability to adapt or manage yourself. So there's kind of the 2 different things: is either an extreme limitation in your ability to do several physical requirements, or a marked limitation in your overall physical functioning, and a marked limitation in one of those areas of mental functioning. That's 11.18. 12.02 doesn't have a consideration of physical. It's strictly mental, and it covers a wide range of neurocognitive disorders. And as you can see, you can either meet by A and B, or just looking at C. 12A is going to require medical documentation of a significant decline in your cognitive functioning in one or more of the cognitive areas, and it lists those 6 cognitive areas there, as well as extreme limitation of 1 or marked limitation of 2 of the following areas of mental functioning, those same areas of mental functioning that we talked about in the last listing. Okay, so with 1202, you have to meet A and B, as opposed to 1118, which was just A or B. Okay, so there's a difference there. You can also meet 1202C if you've got a medically documented history of the existence of the order over the prior 2 years, and there's evidence of the fact that you've got either medical treatment, mental health therapy, psychosocial support, or an environment that is highly structured, and that those are ongoing and diminish the symptoms and signs of your mental disorder, and evidence of a minimal capacity to adapt to changes in your environment or to demands that are not already part of your daily life. So there's kind of 4 different ways to meet the listings. You can meet 1118A, 1118B, 1202A and B, or 1202C. Again, if you don't meet one of these listings, it doesn't mean that you're not disabled. It just means that you don't meet or equal the listing, and Social Security then has to go to step 4 and potentially step 5 to see, can you go back to your past work? And if not, are there any other jobs that in the national economy that you can do? So just because you don't meet or equal a listing does not mean that you're going to be denied. It just means that you don't meet or equal a listing, and instead it's an RFC job availability issue. So certain considerations to make now that you've looked at the listings and kind of have an understanding of how Social Security evaluates the case. You probably understand medical records are paramount. And in fact, I start this slide with that statement, and I close out this slide by saying objective medical records will be important. So it's important that you are seeing a doctor. If you had an inpatient hospital stay following the initial injury, make sure you know which hospital that was. If you had therapy following the hospital stay and or the initial injury, make sure you know where that therapy was done. If you have ongoing treatment, either physical and or mental, make sure you know who is providing that treatment, and make sure that you are telling the Social Security Administration about all of those providers. So that way they can get those records, because medical records are key. As I said, the issue in Social Security disability cases is not just can you go back to your past work, but can you perform any job that exists in the national economy? I get clients that are on short-term disability, long-term disability benefits, VA benefits, and they think that because somebody else has already found them disabled, that Social Security will also do so quickly. That is unfortunately often not the case. And in fact, Social Security, because their rules are different, they're different from long-term disability companies. They're different from the VA. And so they can look at those determinations and understand them and see, okay, these, this agency or this private company has found this individual to be disabled, but our definition of disability is a little bit different. And so that's kind of, and especially with long-term disability, as I say here, it's not just can you go back to your past work. Long-term disability, at least initially, is often looking at, can you go back to the job that you just did, yes or no? And if you can't, then that's often enough to get you approved. After a few years, they'll often conduct a separate review to see, okay, can you go back to your past job or any other jobs? So it becomes more like Social Security's definition, but it still is not equal. So that's important to know too. It with Social Security, they have a very different standard of a definition of disability, not necessarily a standard, but a definition of disability. And they are looking at the listing, and then if not the listing, what is your RFC? Can you go back to your past work or any other jobs? Okay. If you are 50 or older, the grid rules might apply. And then functional capacity can also be relevant, which is what I've been talking about with the RFC. All right, so thank you for sticking with us so far. Here is how an attorney can help you. This is not an exhaustive list, but it's some of the common things that we do several times a day. We provide guidance on what correspondence from Social Security actually means. We file necessary appeals. Either if you are already a client and we get a denial, we can file a necessary appeal after speaking with you. Again, just at the agency level is what we handle. We review your medical records in your case file. We discuss what additional records might be helpful in your case, especially if there are records that are missing. Social Security, they do try hard to get the records, but sometimes you've got a provider that isn't willing to give them up easily. And so they aren't going to continue to chase them and enlist your help sometimes the way we would. We also review your documents for accuracy and completeness. If you're a client of ours or you've spoken with me, you might have heard me say we can't fill the forms out on your behalf as far as the supplemental pain questionnaires, the activities of daily living, the function reports, all of that. We don't fill those out on your behalf. We can, number one, explain what the agency is looking for. And then number two, we can review them before you submit them. But those I tend to consider as kind of testimony without having to go before a judge. It's answering questions that you know best about what your day-to-day life is like, what limitations you have, what you can do, what you can't do. So we are willing to review those for accuracy and completeness for you and get them submitted to Social Security. We work with you to provide relevant updates to Social Security throughout your claim. And if there's an update from the agency back to you, of course, we provide that as well. If we have to go to a hearing before an administrative law judge, we prepare you for that hearing. And then, of course, we question you and any witnesses during that ALJ hearing. The witnesses are not always your witnesses. And in fact, if you are a client of ours, you have probably heard me talk about witnesses at hearings. And if you have questions about that, please let me know. But the witnesses that we tend to question might be a vocational witness or a medical witness that Social Security has requested attend your hearing for additional testimony on your case. That is all we have today. If you have questions, we will go ahead and drop the link in the chat and live again to kind of talk through any questions that you have. If you are watching on the replay, that link is down below. Feel free to schedule a call there. You can also feel free to give us a call directly, send us an email. Our main office is in St. Johns County, Florida, but as I said before, we do assist clients throughout the United States. And if for some reason we cannot help you, we do try to connect you with somebody who can. So thank you so much for joining us today. Have a wonderful day.